Hello everyone. In the last presentation, the rules pertaining to offer and acceptance were explained. This presentation focuses on consideration, which is another essential element of contract. Consideration means something in return or quid pro quo. It is the price for which a promise is bought. It may be in the form of a benefit to the plaintiff or some detriment or disadvantage to the defendant and must be of value in the eye of law. According to Section 2D of the Contract Act, when the promisee or any other person has done or abstained from doing anything, does or abstains from doing a thing, or promises to do or abstains from doing something at the desire of the promiser, the act or abstinence is the consideration for the promise. Where A promises B not to file a suit against him if he pays him rupees 5,000, here not filing the suit, that is abstaining to file a suit, is the consideration for B's payment. Where A agrees to sell his house to B for rupees 50 lakhs, here 50 lakhs is the consideration for A's promise to sell his house, and A's promise to sell his house is the consideration for B's promise to pay rupees 50 lakhs. Promises made without consideration are often made rashly and without proper deliberation, and hence law does not favor such agreements. Now, what are the various rules pertaining to consideration? An act or abstinence amounting to consideration must move at the desire and request of the promiser. It may be done by the promisee or by any other person if the promiser has no objection to it. But under English law, consideration must move from the promisee only. It may be past, present, or future consideration. That is, the act or abstinence amounting to consideration may be performed before promise was made, which is past consideration, or may be performed simultaneously with the promise, which is present consideration, or would be performed subsequent to the promise, that is future consideration. Under English law, past consideration is no consideration. Consideration need not always be adequate but must be of value in the eye of law. So long as the consideration exists, the court will not concern itself as to its adequacy. But the court may take into consideration the inadequacy of consideration while deciding the question whether the consent of the promiser was freely given. Where A agrees to sell his house to B for rupees 10 lakhs, which in fact is worth a crore, the agreement is valid. But where A says that his consent was not freely given, the court has to take into account the inadequacy of consideration while determining the question whether the consent of A was freely given. The consideration has to be real and not illusory. Consideration may not be real because of physical or legal impossibility, or it may be uncertain, like paying reasonable sum for goods or reasonable remuneration for service, or it may be illusory. Consideration must be something which the promiser is not already bound to do by law or by an existing contract. Forbearing to sue, compromising dispute claims, and composition of creditors, that is, calling them to meet and requesting them to accept a lesser amount in satisfaction of their debt, are good considerations for a contract. The consideration should not be illegal, immoral, or opposed to public policy. Persons who are not parties to a contract, that is, strangers to a contract, cannot sue or be sued. This rule is called the doctrine of privity of contract. Privity of contract means relationship existing between parties who have entered into contractual obligations. A contract, therefore, cannot confer any right or impose any obligation on a person who is not a party to a contract. Thus, if a contract exists between X and Y, Z cannot enforce it. But there are certain exceptions in Indian law to the rule that a stranger to contract cannot sue. 1. Trust or charge. Where a trust is created by B in the name of A for the benefit of C, C may enforce it even though he was not a party to the trust. Where an agreement is made with regard to marriage, partition, or other family arrangements, and a provision is made for the benefit of a person, he can sue though he was not a party to the agreement. where two brothers A and B partitioned the joint properties and while doing so agreed to invest in equal shares a sum of money in order to maintain their mother. Here, the mother can enforce the agreement and seek her sons to make the investment because though she is not a party, she derived benefit from it. Where the promisor by his conduct acknowledges or otherwise acts as an agent of a third party, there is an obligation incurred towards the third party. Where A accepts rupees 10,000 from B to be paid to C and admits the receipt of the money to C. C can recover the amount from A, though the transaction was between B and C, as A is regarded as the agent of B. Where the rights and benefits under a contract are assigned to another person, he can enforce it against the party who is under an obligation to perform the promise under the contract. This is not applicable in contracts involving personal skill. Principal can enforce the contract entered into by the agent on his behalf when the agent acts within the scope of authority and in the name of the principal. The general rule is that a contract without consideration is void, but Section 25 of the Contract Act provides certain exceptions to this rule. When an agreement written and registered under law is made on account of love and affection between parties standing in near relation to each other, it is enforceable without consideration. Where a father promises his son to give a lakh of rupees on securing a job in civil services, and this is written and registered, it is a contract and can be enforced by the son. Where there is a promise to pay for the past voluntary service, it is binding. So where A's servant B takes care of A's friend C while he was seriously ill and bedridden for 1 month, and C promises to pay rupees 10,000 for the service rendered by B, it is a contract. Where there is a promise to pay a time-barred debt, it is a contract if it is made in writing and signed by the debtor or his agent. Where A owes B rupees 10,000 and B fails to bring a suit within the period of limitation for money, the right to claim the money is lost and the debt becomes time-barred. Here, if A promises to return rupees 10,000 in writing and signs it, it is a contract. Consideration is not required to create an agency, and consideration is not required for a completed gift, that is, for a gift actually made. This, in brief, is about the importance of consideration as an element of contract and the rules governing it. Thank you.